Welcome everyone to the Young Legal Aid Lawyers virtual event on upholding the rights of disabled children. Thanks everyone for registering and joining. I'm really pleased to be hosting you this evening. I'm Hafsah Hussein. I'm a Young Legal Aid Lawyers Committee member, and I'm also taking some community and youth engagement work in the North. I'm really pleased to be hosting this event today, and such amazing speakers as well, who will be looking at organising, advocating and litigating to address the systemic unfairness experienced by disabled children. And each of the panellists have really interesting and specialised topic focuses within this area. So it'll be really interesting to kind of delve into their perspectives. And I will just give a brief introduction to the speakers before we pass on to our first speaker. And the format of the event is each speaker will speak for about 10 to 15 minutes, and then we'll have a Q&A and discussion at around 7:35 with all of the participants. So please do post any comments that you have in the Q&A function of the chat feature, and I'll be able to pick those up. And if they do link to something that a speaker is saying, I can ask them during the event, but we'll endeavour to save most of the questions to the Q&A. So without further ado, I'll just introduce our speakers. Thank you so much again for taking part and agreeing to be part of our panel today. We have Amanda Elliot as our first panelist, who is a campaigner with Send Action, which is a network of families and individuals and organisations in the UK who are committed to upholding the rights of children and young people. And we are also joined with Polly Sweeney, who is a public law and human rights partner at Rook, Irwin, Sweeney. And she's also consultant at Scotland Creef and chair of the Law Society's Mental Health and Disability Committee, and also contributing author to LAG's Disabled Children Handbook. And our third panelist is Alex Temple, who is a solicitor advocate who supports children access to education and is a public law and policy officer at Just for Kids Law, which I'm really a big supporter of, and really kind of interested to delve into all the fantastic resources that he's created with the School Exclusions Hub. And our final panelist is Ollie Persey, who is a barrister at Garden Court Chambers, specialising in public law, and Ollie is also a co-chair of Young Legal Aid Lawyers. So welcome to all our panelists and to all the participants. I'm really excited to kick off this event, and I'm going to pass it over to Amanda Elliot, who is our first speaker. So you can take it away. Thank you.
Thank you very much, and thank you very much for inviting me to speak on this topic that's so close to my heart. I'm not going to focus on anything legal. I'm not a lawyer, but I want to talk about why parents of disabled children are no strangers to the law, a little bit about myself and a little bit about the campaigning and how those things have come together. I'm parent to Callum, who is autistic and has some quite complex constellation of needs. He doesn't have a classic learning disability, so he's the reason I'm here mainly. One of the things when you're a parent, you find out you're a parent of a disabled child, you know life's going to be a bit harder and it's going to be a bit different, but you're never ever prepared for what is involved at every aspect of their lives. I mean, my son's 22 now, and we just finished fighting a tribunal around his welfare benefits, so it never ends. That's one of the things. I think what we assume is, we're a rich country, one of the richest in the world. The human rights legislation has been around. They've got this, haven't they? They've got disabled children and support, and you know what, they really haven't. And I think the first thing you find out, and one of the things you find out very quickly, is you're not just a mum or a carer, but you also have to be an ACE administrator, a mental health worker, sometimes a home educator, and a constant warrior for their rights. And I'm not an exception in this way. I would say I have lots of social media contact with groups, and you see the parents of very younger children going, oh, well, blah, blah, blah. Is it always this hard? And you can tell the more experienced parents don't want to shatter their illusions, but they go, well, actually, just, strap yourself in. It's going to be really tough, which seems outrageous when you consider disabled children are among some of the most vulnerable in the country, that everything is such a fight. So, that's the reality. And one of the big reality is particularly when your child goes into school, is you assume that they're going to get the support they need. And then where you realise you have a right to request additional support, and the process is painful. People don't tell you what your rights are, what your legal rights are. They tell you what local policy is, or they'll say, oh, well, we'll give it another year, or I think he's doing all right, or and parents get fobbed off by this a lot. And I think it's to do with a system where it's a needs-based system. You know, your child, it's about your child's needs in order to be able to access education and thrive, yet it's being funded and driven by local authorities that are just in the grip of constant funding cuts. So when you ask for something, their default response pretty much always is no, or you can have a bit. A case in point would be typically in Hackney, where I am sitting, which isn't the worst, but it's pretty bad. You know, a child with Down syndrome, you know, really they need regular, particularly in the early years, therapeutic levels of speech and language therapy. Yet, you know, the standard offer that they get is about 8 hours a year. It's just insane. It's sub-therapeutic levels. So children are being shortchanged all the time. So it's the first thing that puts you in conflict in the system, and it's very depressing in that respect. Some people will try the complaints method, but they're long-winded, and you might get a bit of resolution and an admission that they haven't done anything, but rarely do processes change as a result of that. So in terms of not being a stranger to law, I mean, you learn very quickly, if you've got good people advising you and good peer support, that you only have one route of redress, and that's an appeal to the tribunal, or you could judicial review a school if they're not implementing your cert. And I learned the hard way. So when my son was 5, he'd had all his diagnoses. I had to go through a refusal to assess, and they told me, well, it's not policy, we don't support children like your child. And I had no clue what I was doing, but I challenged it, and he got what was then a statement, and I was delighted, and I walked away. What I didn't realise, because I was there wasn't the advice or the social media back then, was he actually needed speech and language therapy. So he went 5 years at school in a mainstream primary without any speech and language therapy, and the result of that was he became increasingly violent. He was constantly taken out of, he was managed, but he wasn't taught. There was exclusions. It wasn't a bad primary, they're really sweet, but he wasn't getting the right support. He could not express himself, and therefore it became very challenging behaviour. So, you know, parents are no strangers to the law anyway. And I think to that long list of things that we become, warrior, administrator, you could put hyper-vigilant paralegal as well, because suddenly someone tells you, if you're going to a tribunal or you're going to challenge any of your provision, you need evidence, you need all this evidence. And so you start taping conversations and having email trails, which is stuff you thought you could just have a chat with your school. But this is something that many, what I would say for all those parents that do find out this is your route of redress and get good support, there's a whole bunch of families out there who, for whatever reason, are terrified of this. So they'll go, it's really bad, my son's being excluded, he hasn't got support. And suddenly, and you will say to them, I mean, I set up a forum in my borough, and we say to a lot of the times, look, you really do need to appeal. You haven't got any choice in this. And they often delay you because they're so scared of the law. They're scared of making trouble or being picked on if they go down that route. And often that's a cultural thing. So I'd say not universally, but there's certainly a lot of hesitancy, yet there's a huge amount of need. So I think that's one observation worth making. But I mean, the one good thing at the moment is social media, which didn't really exist when I was younger. And there's just a plethora of incredibly informed parents and support groups up and down the country. So if somebody posts something, they get great advice, and then they get signposted to various support and told that, you know, you do need to take some kind of legal action. So you soon become very intimately aware of the code of practice and rights. And a lot of people go and train with IPSI. A lot of parents will go and become an IPSI advisor, which is the charity that supports legal charity that supports family, so they can give advice to parents on the phone. So that's how we are. I think I ended up having a second appeal for my son because he needed specialist provision and they resisted that, and that was at 10. when he was 10 or 11 and to secure a specialist provision. It was a hell of a fight. It was the most horrible year of my life. It turned me into a quaking monster, but they folded a month before the tribunal. So they put me through all this and then they agreed to the placement. So there's a lot of parents that you may deal with are suffering from really a lot of chronic stress. And I think, you know, if you end up supporting them individually or as part of a campaign, it's worth being aware that the kind of almost like a form of PTSD at the end of it, that, you know, that they don't trust anybody, they feel gaslighted by local authorities who are trying to preserve funds. You've got to be incredibly tough to be able to, and we get very fed up as carers being told that we need to be more resilient. I think we find it really offensive. So what I want to talk about a little bit now is the campaign. So I'm in Hackney, and about a few years ago, they were starting the cuts, the funding for special ed was being spread too thin. There wasn't enough funding, and various campaign groups separately were getting together to take judicial reviews against their local authorities. Bristol was the first out the trap and they won theirs. I can't go into the details, but it was like, wow. And then Surrey went into court, and in Hackney, we'd been involved in a mass consultation. They actually did consult in Hackney. We mobilized massive, 2,000 people responded. And we had a demo, like a candlelit demo outside the town hall. We went all full out, and we were amazed how many people came out. Some people had never been on a demo or had never protested in their life. And we got a lot of media attention, and we challenged their cuts. They pushed them through anyway. No, they reversed part of them, but went through ahead with 5% cuts that weren't in the consultation. So we were scratching our heads. What do we do? You know, they're ignoring the key point. And so it was at that point we started taking legal action. We found 3 families who were eligible for legal aid, and we proceeded and took them to judicial review. We crowdfunded very quickly. We collected the money for sort of some pre-action legal letter beforehand, and it took us a couple of days. So that was us off to court, and we didn't win, and neither did Surrey, but we never felt or regretted for a moment that it wasn't worthwhile, because what happened is we started to generate in the years of Brexit, when it was the only thing in the headline. We were protesting locally and nationally, and suddenly we had visibility, and we had great support from all the lawyers. I mean, I have several Send heroes. Some of them are on this panel, and some of them, I mean, Steve Broach, we have and also individual families. There's Mary and her daughter Dakota, who were litigants in the national case. So soon after that, we was my friend and campfire campaigner Gillian Doherty got us all together and said, we need to take legal action. We need to take this really high. And we pulled together some people, and we started trying to gather some evidence, and that's how the National Judicial Review came about. And it got an enormous amount of attention. We had a big demo outside on the day of the hearing. We had a lot of adult disability organisations came to support us. It was phenomenal. We rammed out the courtroom. That was the best thing. We had all those people in wheelchairs, autistic children. We just rammed it out, and campaigners in our t-shirts. I'll just show you my t-shirt there. Sorry, that was a bit rude. And we generated an enormous amount of headlines, you know, breakfast TV, and we were trying to manage the media outside. And it was very empowering. At the same time, there's like another national group of parents who were there's big overlaps, who are holding small demonstrations up and down the country in May as well. So there was a whole build-up behind it. And actually, as you know, we didn't win the national JR, but what happened was in the September afterwards, they found another 178 million for special educational needs. It was a drop in the ocean, but it was an admission that there was a problem. There were National Audit Office reports into the failures of special education needs in this country. And then there was an Education Select Committee inquiry, which the findings of which we're hoping there's a government Send review that's due to special educational needs and disability review that's due to report in the spring, and which we hope will be informed by all of the problems that we expose by taking legal action. I just wanted to make one last thing about the COVID pandemic, because things were really, really bad before the pandemic. But what the pandemic exposed to us was it amplified and exposed all the problems that those families and children were experiencing prior to the lockdown. There are two really good surveys out there, one by Special Needs Jungle that was published about 2 days ago on the experiences of families called, I think it's Denied Provision, and also the Disabled Children's Partnership produced Left in Lockdown in the summer as well. And it's quite clear that it's just made things 100 times worse. And out of this, and the other thing I think that scared us all was when last summer, when they started legally easing the duties on local authorities for vulnerable children, we were absolutely horrified. It was like, we thought these, you know, we didn't have much, but we had the law, and they were like gossamer. They were just sort of so fragile they could be taken. And one of the findings of the survey, the Special Needs Jungle survey, is that vast numbers are still not getting their provision, even though those duties were restored in September on paper. That loads of people are not getting their provision, loads of kids are out of school, there are massive delays around education, health and care plans, which were delayed before anyway, not to mention the huge mental health issues that children are experiencing, and many are going to be going back to school in a couple of weeks only to be excluded or off-rolled again, which is, the parents know what this is going to be like, and I just think there's never even more of a need to defend disabled children's rights and fight harder, because things were bad and they've got worse. And I hate to say that as a campaigner. I want to know that things have improved. So yeah, it's always work. We tell all parents individually, the law's all you've got. Nobody else is fighting your back. And so yeah, I think that's it. I don't really have anything additional to say, except, you know, there are some amazing lawyers out there. The relationship between parents of disabled children and lawyers out there is I think an unusual one. Is that, you know, we've all got Steve Broach on our Facebook pages. We don't pester him, really, we don't, but he's a friend as well as a, you know, a titan for us, and he's inspired us from the early days, but he's not the only one. So, you know, it's really, we're really grateful for all of you guys that fight for our children, you know. Anyway, thank you.
Thanks so much, Amanda, for sharing all of your reflections, and particularly what you mentioned about how often parents are, you know, playing so many roles in fighting for their children's rights, and having to be a paralegal, admin worker, and dealing with, you know, such a stressful process. So I'm really grateful that organizations like Send Action is there as a supportive network for families going through such a stressful process. So thanks for sharing more about the kind of campaigning work that you do. And also really pleased to hear about such a huge turnout for your the demo that you organised, and that it is so worthwhile. Whatever the outcome, those displays of solidarity are always recognised in some way, I hope. So thanks so much for sharing those reflections. I'll pass on now to Polly Sweeney, and hopefully in the Q&A we can talk about some of the aspects that you mentioned in more detail. So Polly, you're up next. Thanks so much.
Thank you so much. And it was great to hear from Amanda first to put this all into context. And I echo everything that she said, and that's my experience in the clients that I represent and their experiences on a day-to-day basis. I don't think anybody would defend this system as being a system that works well for children and young people. It is a system that's in crisis. There are, I think, around 400,000 children and young people at the moment across England with education, health and care plans. And that number is rising year on year. And at the same time, the number of breaches of law in this area and the number of complaints that parents have to bring and young people have to bring is also rising exponentially. And so the Local Government and Social Care Ombudsman issued a report in October 2019, looking specifically at SEND complaints. and revealed that it upheld 9 out of 10 complaints about SEND that are brought by parents, which is way higher than any other area that the Ombudsman investigates. And that's also borne out by the statistics in the Tribunal as well. So there were almost 8,000 appeals registered in the Tribunal last year, which is up over 10% from the year before, and the largest number ever recorded, and that's despite the impact of COVID. So we have almost a perfect storm of a group of children, young people that's increasing in size, and then a system to support them, which is in crisis. And the reality is that there is nowhere near enough lawyers to be able to address and help every single one of those children, young people that need to access to legal advice and who have legal remedies available to them. There's been breaches of their legal rights. So my first point would be a call out to everybody here that this is a really demanding area of law, but it's one where we really need more lawyers. We need good lawyers to do in this area of work, because there just aren't enough of us. But also, because we're just not able to individually address every single breach of each child's rights, strategic litigation in this area becomes really important, because what we can do through strategic litigation is we can bring one single challenge on behalf of a couple of claimants that has the potential to benefit a much larger cohort of children and young people. And you heard from Amanda all of the campaigning work and the legal cases that Send Action and that group of claimants were involved in. And very often, it's not winning the judicial review that makes the biggest difference. It's the scrutiny and the wider public awareness that that challenge will bring that can bring about real benefit. And so, as Amanda said, in some of those budget, the national budget challenge, okay, that wasn't successful, but I don't think it was a coincidence that the government committed a huge increase to funding in that area as a backdrop against that judicial review challenge. So it isn't just the winning of these cases, it's the bringing them, which often is just as important. And I think a good example of that is, and the case that I will just spend 10 minutes talking to you about as an example of strategic litigation in this area, is the case that I worked on over the summer. And as Amanda mentioned in her talk, children's rights pre-COVID were already being routinely breached. We all know that from the cases that we see every day. But the government's reaction, the government's response to the COVID pandemic was to downgrade children, young people's rights so that they no longer had these very clear-cut enforceable legal duties to their provision under Section 42 of the Children and Families Act, like they did before. And so it then became even more difficult. So when you have a system that's already not meeting needs and not complying with the law, when you already have very clear-cut rights, it's no surprise that when you downgrade those rights, they're not going to happen at all. And that's what we saw, is that overnight, many, many children, young people lost their provision in their EHC plans completely. And they no longer had the enforceable duties under Section 48 to rely on, because the duty was downgraded to one of reasonable endeavours. And that's a much more difficult argument, legal argument to bring. And so we were instructed by 2 claimants to bring a judicial review against the Secretary of State for Education in the decision to downgrade the Section 42 legal rights and duties, and also the downgrading of the timescales in which to comply with assessments and other legal duties that they had. It was a particularly challenging judicial review to bring, because the way that, as you know, the way that judicial review works is that you have to have a focus of your decision, you have to have a decision that you're challenging. And the nature of these decisions that were being made by the Secretary of State for Education were that they were being made on an effectively rolling basis. And so there would be a decision to downgrade for a period of 1 month. And so we had a notice at the end of April to cover the period of May. Then we had a new notice in June, and then another notice in July, and they are effectively each time fresh decisions. And so I think the biggest challenge in this case was making sure that we had a live claim in the court that wasn't academic. And that's really difficult, because in order to have a claim that isn't academic, you need to comply with the pre-action protocol against the decision you're challenging. You then have to get your claim issued in court, you need to get permission, and you need to be listed for a substantive hearing within a period of a month. And that's pretty impossible in judicial review terms. And in fact, that was acknowledged by the judge in the course of the case, that it isn't generally possible to be able to do all of that within a short period of time. And in the judgment, the judge gives a warning to the government that it shouldn't use these sorts of powers as a way of stopping scrutiny over its decision making. So that was a particular challenge in the case. And what it meant is that we had to make sure, as legal representatives of the claimant, that we were amending our claim, so that each time there was a new decision, we were formally amending it, so that at the point we were before the judge, it wasn't academic, because there was still a live decision which was being challenged. The claim was brought on a number of grounds. A failure to consult before the decision making, and a real striking feature of the case for me was when looking through the disclosure from the Department of Education, the lengths that the government went to consult with local authorities, very exceptional lengths, hundreds of telephone calls to different local authority representatives to get their views. But there was no consultation at all with parents and children directly. So ultimately, though, the judge found that, as has been the way with a number of these COVID-related judicial reviews, that in the circumstances of an emergency pandemic, that it was reasonable and that there wasn't a duty to consult in these circumstances. The judgment wasn't successful. The judge found that the way that the decision had been made by the Secretary of State for Education didn't breach any of the public law principles in terms of consultation and rationality of the decision. But I think it's really telling of what happened next, in that our case and the claimant's case throughout was that there is no need to formally downgrade these duties, because where provision obviously can't be delivered. So, for example, a child has in their EHC plan that they need to have small group work with their peers, and their parent is educating them at home. Clearly that can't be done, but no parent is going to try, with everything else they have going on, is going to try and enforce provision which obviously can't be provided. And that was our main point, is that this risk of litigation, which was said to be the driver behind these changes, is to prevent local authorities from being challenged for not delivering provision they can't deliver, is that parents just wouldn't do that. And actually, it's very interesting to see that although the case wasn't successful, in this most recent lockdown, the government has in fact done what claimants suggested and take a much more reasonable approach, which is not to officially downgrade the duties, but really to employ a common sense approach, in that schools should work with parents to look at what provision can still reasonably be delivered, and to accept that some of this, it might be impossible to provide. And where it's impossible to provide it, then nobody really is going to be doing anything about that. And my view is that there is no easy solution to this. With large numbers of children and young people out of school, there wasn't a magic answer to this, but my view is that that was the right solution in terms of how to deal with this difficult situation that we face. So yes, strategic litigation in this area, as I said, is in my view really, really important in trying to address some of the bigger issues that we're seeing, and trying to affect a wider change than just a single claimant's case. And we have a number of cases which that are being brought, that are in the pipeline at the moment, that are being brought by SEND lawyers. I'll give you another example, I think, of the sort of challenge that we can be looking out for in systemic legal challenges. And so there was a case that was brought by a Southwest local authority. We all know, if we practice in this area, that one of a real challenge is that you will have an annual review of a child's EHC plan, and there'll be some really productive discussions about it. But then, and some amendments to the EHC plan might be agreed as being needed. And then months will go by and you'll never hear from the local authority to update that EHC plan. And it happens routinely. And at the moment, the legal duties on the local authority in terms of the timescales with which they have to take steps after an annual review aren't clear cut. And so a case has been brought by another law firm to challenge that and to seek a finding via judicial review that actually there are time limits here. And that is currently going through the appeals process at the moment. It was heard by the Court of Appeal a few days ago. But that's exactly the sort of strategic litigation that has the potential to improve some of these real systemic issues that we have. And so I would say, you know, work with charities, find out what are the big issues in your local authority area, you know, at a national level. What are the things which are having the biggest, what are the biggest blockers in children receiving the provision they need? Is it policies that are in place? Is it, you know, failures that are happening too often? And then look to be gathering in as much data and as much evidence as you can to show that this is a wider issue. And I think working with charities like Send Action is a really, really good way of doing that, because for strategic litigation, for systemic challenges in particular to work, you need to be able to evidence that this is a much bigger issue. And we really were benefited in the judicial review over the summer by some great evidence from the charity sector, and using the surveys from Special Needs Jungle, you know, Send Action and IPSI and SOS SEN. They were really integral in making sure that we had really good evidence before the court about the impact of the decision that had been made on children and young people. And so, yeah, I would just end by echoing what Amanda said about how this is a great community to be part of. And it's wonderful to see parents, charities and lawyers all working together to try and solve some of these big issues. But we have still a long way to go and a lot of work to do. Thank you.
I think, have we lost Hafsah?
Yeah, I think he's frozen.
She's frozen by the looks of things.
Or being very still.
Yes, impressively so. I think I was next on the running order. So whilst she reconnects, I might just start so that we are keeping things moving, and hopefully she can reconnect shortly. So my name's Alex, as was mentioned in the introduction. I'm from Just for Kids Law. I'm a public lawyer and policy officer. And obviously those were two really fantastic presentations. I'd echo what Polly said about Amanda's presentation. It's so important to have a relationship that works between the lawyers in this sector and the families. And I think that more often than not, maybe it's just me, I can't speak for everyone, it's the lawyers that are in awe of the amounts that families of sending people have thrown at them, and are just constantly fighting. You know, we join these battles sometimes a decade into these huge, great long histories of tribunal after tribunal and complaint after complaint, and it's inspiring, and it's what keeps it's what keeps local authorities and the national government in check, to be honest. So I'm going to talk. I'm going to share my screen if I can do that successfully. Yep, success, I think. If anyone can confirm that they can see it, that'd be great. Yeah, lovely. So I'm going to be talking specifically about the relationship between disability in school and school exclusions from the research that exists from our experience, and also talking a little bit about the need for change. Now, just to be aware, there'll be some slides in this slideshow that I'm not going to talk about, simply because I wrote it and I got very excited about covering all this really important stuff, and then realized I don't have the time for it. So I left the slides in there because either YLAL can share them afterwards, or if anyone has interest in reviewing them, please definitely do get in touch with me. I'm very happy to share the slides and speak to any of them that we didn't get to cover further. So firstly, what about disability and the right to education? Well, this we can cover very quickly because it's already been touched on, and I'm sure everyone knows the basic principles already. Disabled children, just like everyone else, should receive an education that's suitable to their ability, age, ability, aptitude, and special educational needs. And an exclusion is obviously going to be an affront to this principle. An exclusion is going to be an interruption to a young person's education. And the law is very clear that it must only be imposed in response to a disciplinary incident or incidents, which might sound obvious, but actually when you get down into it, what you'll find is that schools might resort to exclusion because they feel they can't meet the provision for a young person. They're struggling to address a young person's need, and so that they say, well, this is a mechanism for getting a young person out of school. That's not lawful. And kind of on the even more nefarious end, you find schools excluding young people because they're concerned about their rankings in school grades, or as we've seen on occasion, they're concerned about safeguarding issues, and so resort to exclusion as if it's doing everyone a favor and keeping children safe, which obviously is not true, and I'll get to shortly. But even where a disabled pupil's exclusion results from behaviour, if that exclusion results from behaviour that flows directly from a young person's disability, then that can constitute discrimination. Discrimination which a school might try to justify, and potentially successfully so, but discrimination nonetheless, because it's something that's a detriment to that young person, and it's arising out of their disability. And finally, of course, again, as I'm sure I don't need to tell anyone on this call, disabled young people have a right to reasonable adjustments to be made for them, which includes to a school's behaviour policy and other policies. Again, I'll get to how that kind of plays out between different schools shortly. But it's really significant because, to put it bluntly, a behaviour policy that works for some young people and that is a reasonable expectation of some young people isn't going to be a reasonable expectation of other young people, not without support that's effective and that often takes a long time to take effect and to tweak to that young person's specific needs. So what do we know about the impact of school exclusion? Well, as I'm sure is not going to come as a surprise, given the context, it's very significant indeed. So children with SEND, to start with, are massively overrepresented in school exclusion statistics, being up to 5 times as likely to be excluded as the national average. And that doesn't even differentiate between SEN, special educational needs, and young people who are disabled for the purposes of, say, the Equality Act. And we don't have we don't have the stats broken down along those lines. From our experience, and I think from the literature, you'll probably find that unsurprisingly, if you could break statistics down along those lines, that statistic would be even more stark. And as for the children who are excluded, well, those who are permanently excluded or suffer multiple fixed term exclusions, unfortunately, have very low academic prospects. This is particularly true for young people taking their GCSEs after a permanent exclusion, because what they'll do, what will happen is they'll be referred to what's called a pupil referral unit, and evidence submitted to the Parliamentary Education Select Committee a couple of years ago found that only 2% of young people who take their GCSEs in a pupil referral unit actually achieve 5 or more good standard GCSE grades. And of course, the really upsetting thing there is so many of these young people have massive potential, and they're doing, and often at the time they're excluded, their academic performance is strong, and of course, even for those who are struggling academically, it's still a really shocking statistic, and shows the enormous impact that exclusion can have on a young person. And in addition to that, excluded young people are much more vulnerable to coming into contact with the criminal justice system, particularly as victims of child criminal exploitation. Child criminal exploitation, or CCE, is the practice of coercing and manipulating young people to engage in criminal activity. People who aren't hugely familiar with this area might have seen it reported in the news within the context of county lines drugs trafficking, where young people are basically forced into acting as couriers for illegal substances, of course, which is massively dangerous for them, both in terms of what they might happen to them in the criminal justice system, but also tragically in terms of life and limb as well, and it can be fatal in some really tragic circumstances. We know that criminal actors prey on young people who are in pupil referral units, and also that they prey on young people that are out of mainstream education, particularly young people with certain disabilities that make them more susceptible to control, to exploitation, and into simple peer pressure as well. And so that's a really massive problem, and it's one that's been acknowledged by the Department for Education, by Ofsted, and by the National Crime Agency as well. We know that it exists. It's just about moving on and fixing it. Exclusion can obviously trigger and exacerbate mental health needs. I mean, one of the things that young people tell us all the time is the feeling of isolation and shame and anxiety that comes after an exclusion, particularly where it's come from a disability, and therefore it's behaviour that they haven't chosen to engage in. It's behaviour that flows from something that is innate. Exclusion, of course, one of the really big problems is it comes with no process for continuation or handover of support. It's like flipping off a light switch. It's the exclusion process. Once a head teacher has taken that decision to exclude a disabled young person, the review system basically asks a yes/no question. Are they going to be excluded, or are they not going to be excluded? And if they are, there's no framework in place for continuing their support. Now, as has been touched on, a lot of young people with SEN have got an education, health and care plan, which is a plan that's intended to describe the support that young person needs and follow them from place to place. So if you move from one school to another school, that plan goes with you, and all the support that it's intended you should be receiving at one school, you should receive at any school, because the local authority maintains it. But it just doesn't work like that in reality. And I think that what we find is that a school obviously develops an institutional knowledge of a young person, and every young person with an HCP has a unique set of needs that can't simply be written down and left. And so as a school gets to know them, particularly frontline staff members like classroom teachers, they get to know how to interact with a young person, they get to know what works for them, what doesn't work, and they build those personal relationships. A lot of the time that just isn't written down, and if it is written down, that's not an effective way of translating it between two different institutions, two different big educational institutions. And so when a young person is excluded, they just lose so much institutional knowledge. There is no effort to capture it and move it with the young person. And so even if they're lucky enough to get into another mainstream school or a special school that's tailored to their needs, there's a huge process of getting them back into a place where they are supported to a level that they deserve and are entitled to. So given that, I think that we would expect that the exclusion review process would be a really robust assessment of a head teacher's decision, and a real good faith effort to understand what it is that's gone wrong to bring them to the point that they've been excluded, and whether or not that exclusion is lawful and appropriate. And again, I'm sure you won't be surprised from the context and from my tone of voice that it's simply not the case. There are huge shortcomings in the exclusion review process. So we're going to start with what we call the administrative process, which is starts at the school's governors. Every permanent exclusion and some fixed term exclusions must be reviewed by a school's governors. And of course, a governor's interests are conflicted by their nature. They are they have a relationship with the head teacher. Sometimes they'll have appointed that head teacher. They work with them on a day-to-day basis. And even the National Governors Association has said it is not appropriate for governors to be put in that position, which is fair. I think it's massively fair that it's an impossible ask to make for governors to be impartial in that situation. And the second is that it's simply not what governors are intended for. They're intended to have strategic oversight of a school, and not to basically be acting as judge in these acrimonious legalistic disputes between what is essentially two parties, school and family. And so families can appeal to what we call the independent review panels, and they will do a lot because the governors uphold the exclusion an overwhelming majority of the time. Independent review panels They are a lay panel, they are independent from the school, but unfortunately they cannot reinstate a young person. It's so absurd, and it causes intense frustration for families that they can win their independent review panel, and the independent review panel can quash the exclusion, the governor's decision to uphold it, but all that does is it sends the decision back to the governors. They can simply uphold it a second time. And only 1/3 of positive IRP decisions, as in favour of a family, translate into an offer of reinstatement back into the excluding school. There's no legal aid for either advice for families or to obtain relevant expert evidence. And that's important because independent review panels, they can have an SEN expert available on request, but that SEN expert will not assess the young person, and so won't provide a report for the panel. And if you want to get reports as a family, you're going to be paying for it most of the time, unless you can find someone to do it pro bono. And of course, that's hugely problematic. And it means the IRPs are often making decisions without appropriate information in front of them. Families can appeal to the first-tier tribunal if the young person meets the threshold for disability within the meaning of the Equality Act. And of course, as I said before, SEN doesn't necessarily mean disability. Of course, the FTT only considers questions of disability discrimination. They don't take cases that involve disabled young people, but regard questions of process and procedure and the public law grounds that are so important to a lot of these decisions. And whilst they have an expedited procedure, which is really important because the FTT a lot of the time has a very long waiting list, they won't consider it if they're waiting for a decision from the independent review panel. They won't use that expedited procedure. So it's really vital that families can have effective access to the IRPs, and they still have a really important role to play. Finally, young people don't have their own right to appeal in the administrative process. Which is really frustrating because, of course, firstly, a young person should have their own autonomous right to make decisions about their future. That's basic common sense, and it is their right. It's a question of rights. And second, whilst most of the time a parent and a young person's interests and objectives will be aligned, not always. And particularly, we've had problems where a young person has a corporate parent. Local authorities have a lot of difficulty sometimes going up against a school, particularly an academy school in their area with whom they rely on the cooperation. And we've had local authorities that really put up roadblocks to bringing an appeal against a school exclusion, and won't support a young person within their care to do so. I'm not actually going to talk any further about the first-tier tribunal because I've covered it, and like I say, these slides can be distributed afterwards, or you can ask me for them. What we see in our casework. So even successful appeals can take a long time. We've just concluded a judicial review that actually 2 judicial reviews for the same case on the same exclusion. This one young person went through 2 independent review panels, 2 governor's hearings, and 2 judicial reviews for the same exclusion. They have now been reinstated, and they've retaken their place at the excluding school 16 months after the date of their exclusion. 16 months out of their excluding school, and they've only just been able to accept reinstatement and get back into the excluding classroom. That is not a functional system, and that is not a system that justice delayed is justice denied. And I think that's a very acute example of that. They've lost a year of their life. They had to repeat a year of their school to an unlawful exclusion, one that should never have happened in the first place. Zero tolerance behaviour policies have a grave impact on the inclusion of disabled pupils. So some zero tolerance schools are those schools that say, I've had it written down in a behaviour policy like this: punishment first, ask questions later. So as in, we will think about what might have been done differently. We will think about the impact on disabled children, but not until after we've done something, imposed a disciplinary response. So often that might be, I've seen policies where it's, if you do something wrong in the classroom, you go to isolation, and you've got to be in isolation within 2 minutes of the classroom teacher calling down to isolation to tell them to expect you. And then once you're there, they can start thinking about whether or not you need more support. And if it keeps going, they might think about whether or not the behaviour policy is working for you. But there's 2 problems there. The first is that you shift the goalposts for disabled children, and you say, well, it's okay to be disabled, but within this little section. You can be this much disabled within this context, but actually once you're outside of that, even though your behaviour relates to unaddressed need or might relate to a disability, it's not okay. It's not okay. And even though a lot of the time, other young people in the classroom will be aware of a young person's special educational needs, particularly and definitely staff at the school, and yet we're telling young people that actually you have to achieve the impossible, and if you can't achieve the impossible, you're not welcome in the classroom. You can't be in the classroom. And this becomes particularly problematic when we consider the most common reason for permanent exclusion is persistent disruptive behaviour. Now, what that means is not one big incident, but lots of little incidents. And what we often see is once a head teacher has reached the decision to permanently exclude someone, they've gone through an escalating series of individual punishments that are less significant, in quotation marks. So it might be a detention, then a Saturday detention, then isolation, then fixed term exclusion, then permanent exclusion. But at no point has the school stopped in that escalating series of disciplinary responses and thought, actually, this isn't achieving results. We're disciplining someone. And obviously the objective of doing that is to change behavior. We're not changing behavior. Now, I would say, well, then, because that might be because it's not within that young person's, it's not a disciplinary issue. It's an issue of a lacking support or improper support or support that's not working. The schools don't often pause to reflect on that and put purposeful action in place to correct it. Finally, simply that understanding can be limited within schools. I think we've heard that, it's simply that particularly as a part of teacher training and a part of ongoing school training, disability and SEND, simply it's not as an integral part as I think a lot of people assume. That was certainly my shock when I started working in this area, was actually I just thought that there had to be more understanding in schools, that it was a part of the institutional training framework. So please do someone stop me if I'm going way over. I promise that I'm near the end now. Off-rolling and informal exclusion, I'm not going to cover it here because it's a topic in and of itself. It's huge. Safe to say that it's basically exclusions that don't make it into formal exclusion statistics. They're not reported. They don't trigger a formal process. And research suggests that they are a growing phenomenon. They are an illegal phenomenon. They're incredibly pernicious and nefarious and damaging and awful, and also that they fall along the same lines of disproportionality. So they overwhelmingly impact disabled young people and young people with special educational needs. I'm also not going to cover the role of the local authority. Again, we've touched on it before in the presentation. I'm sorry, I'm not just, I promise these slides are here in good faith. And again, with the involvement of Ofsted, it's its own presentation, and I'll touch on it briefly in our recommendations. So here we go, calls for change. So exclusions must be brought back within the scope of legal aid, both in the administrative process and in the FTT. Exclusions are huge. They're huge and complicated. There's one paragraph in the exclusions guidance. And remember, this is the guidance that families are expected to be able to navigate and put into effect by themselves without legal advice. And it says, the school exclusions process involves the application of the public law principles of the Human Rights Act, of education law and equality law. And a family's got 15 school days from the date of the exclusion to learn that and get ready for hearing. It's absurd. There was actually a case in the High Court a few years back that found even the role of the independent review panels is just bizarre, because it said that, well, Parliament's intention in designing this area of law was clearly that independent review panels had to undertake a judicial review as far as possible. And the judge basically said that's an unsatisfactory thing to require them to do, but it's what they were required to do. A lay panel of people undertaking a judicial review. IRPs must be replaced with a body capable of directing that a student is reinstated. That just seems like common sense to me. And governors panels must be abolished in favour of an independent person or body. I don't think that I hope that I'm not speaking out of line when I say that I think many governors would support that. In terms of both of those recommendations, I highly, highly recommend anyone interested look up the Justice report from 2019 called Challenging School Exclusions. It's a really, really fantastic report, and not just because we were involved with it. It's got a thorough and comprehensive range of recommendations on the entire system, start to finish. Not just on how to get young people to access justice, but actually how the whole thing can be improved to be a problem-solving, investigative system that's going to do better for young people, no matter what the outcome, whether they end up leaving the school or not. Young people must be able to bring an appeal in their own right. And finally, Ofsted needs to conduct a thematic review of off-rolling. So Ofsted, the only thing I will say is they've come down very, very hard, rhetorically speaking, on the use of off-rolling and disproportionate school exclusion, but we've seen very little evidence that that's translated into concrete action. I think just an increase in transparency and a thematic review, which they can do, and they can use their powers to inspect schools within the context of understanding and the national picture of a certain phenomenon, and they should do so in order to better understand what's happening in schools and to really take action against schools that are unlawfully excluding disabled children and all children outside of the formal systems or by abusing the formal systems. Thank you very, very much indeed. The last thing I will say is that this is the School Exclusions Hub. It's on Just for Kids Law's website. It's a resource, a comprehensive resource for helping professionals who are interested in supporting families to navigate the administrative process. It's got guides and downloadable resources. Please do check it out. And if you've got any questions about it or you're interested in using it, definitely get in touch. We are here and we are funded to support people to access the School Exclusions Hub and to make use of the resources. So if you're interested, but you've got more questions, please do get in touch. And thank you so much. I hope I haven't gone over time. Do we have our host back yet? I wonder. Ollie, if you're talking, I think you're okay.
Yeah, I think Hafsah's back, yes. I am just going to share my slides. Great. Thank you so much to Amanda, Polly and Alex for those fascinating presentations. Hearing Amanda speak is always, hearing a family member speak, it's always really powerful to remember exactly what's happening on the ground and the emotional cost of all of this. And that links into my presentation in particular, because I want to speak to how we address the inequality of arms in the whole process, and also how we can ensure that as many SEND families as possible can access judicial review, the remedy that Amanda spoke so powerfully to, which has really transformed their campaigning. So, the inequality of arms. So, in my presentation, I'm focusing on the inequality of arms in the Special Educational Needs and Disability Tribunal, the SEND Tribunal. And there are broadly two types of case that you see there. Appeals in relation to education, health and care plans. So the really important provision that's provided to children with special educational needs. And there are related challenges to failure to assess for that, failure to issue, etc. But there's that stream of work. And then there are the disability discrimination claims that Alex spoke to as well. And as Alex mentioned, there's no legal aid for representation in the Special Educational Needs Tribunal. There's legal aid for what's called legal help stage, which helps a family prepare and you can get expert evidence. But when you get to the tribunal door, unless you can get someone to act pro bono, which many barristers do, many solicitors do, and there are great charities like IPSI, which provide volunteer advocates. The families on their own, unless they can access that support in the SEND tribunal process. Weirdly, legal aid then comes back in scope for the upper tribunal. So there's this lacuna of lack of funding for the Special Educational Needs Tribunal and the representation there. And that didn't sit well with me. And when I used to work at an organisation called Public Law Project, which does a lot of work around exceptional case funding. And I'll speak to the work that we did at Public Law Project on this issue in a second. But it's worth remembering that while the families might not have representation, local authorities very often do. So I'm acting pro bono on Friday for a family, and I'm up against someone that's going to be a SILT very soon. And the local authority has lawyered up, essentially. And it's very, very common. And statistics published by Special Needs Jungle recently showed that in the last 6 years, local authorities have spent £200 million on representation in SEND tribunal proceedings, and then gone on to lose 95% of the time. When it could really have been spending that money, instead of battling families, they could have been spending that on provision in the first place. But there's that inequality of arms. Families going into the tribunal unrepresented, local authorities lawyered up. It's a form of gatekeeping. The whole process for SEND families is a gatekeeping experience. They're resisted by delays, failure to assess, failure to issue. Its whole process is a way of local authorities stalling, complying with their statutory duties. So even if you are able to get hold of a lawyer you might not qualify for legal aid. And it's worth remembering that the means test for legal aid is really quite strict, and it will be assessed on the parent's means rather than the child's means, because as mentioned, while young people have a right to bring an appeal to the SEND tribunal, children don't, and the appeals are brought in by the parents, so their means are assessed, which excludes lots of families from being financially eligible for legal aid. So moving on to exceptional case funding, when I was at Public Law Project, and I'm continuing to do it since moving to Garden Court a couple of months ago, I've been working with education law legal aid providers to explore applying for exceptional case funding. And this is effectively the safety net for areas of law that are out of scope. So there's no legal aid available on the face of LASPO, the Legal Aid Sentencing Punishment of Offenders Act, which is the most hated piece of legislation among all legal aid lawyers, because it was a slash and burn of legal aid. But even before LASPO, legal aid for representation in a SEND tribunal was not in scope. But Section 10 LASPO makes clear that exceptional case funding is available. So basically, cases can be funded by legal aid if certain criteria are met. And put simply, there has to be a risk of breach of a convention right or now retained EU law rights. And the principal one in play is Article 6, the right to a fair hearing. And the criteria that they look at in determining ECF applications, the legal aid agency, when they're reviewing these, are the complexity of the case, the importance of the issue in hand, and the capability of the person to represent themselves. Now, taking the importance of the issues in play, how many issues are more important than a special educational needs provision for a disabled child or someone with a learning difficulty? It's clearly, squarely an important issue. Then complexity. Well, the legal duties are actually perhaps not that complex. They're relatively straightforward compared to other areas of law. But some of them, particularly if you a national trial case where health and social care issues are in play, it gets trickier. What's more, the factual complexity of SEND tribunal, of SEND claims is huge. You're looking at expert evidence report from speech and language therapists, educational psychologists, etc. Then looking at the capability of people to represent themselves. Well, one of the criteria that is relevant for the convention test is emotional attachment to the material. Can you be emotionally disconnected and effectively advocate? Well, it's really difficult if you've fought tooth and nail with a local authority to try and get provision in place to have an emotional detachment and be able to do the work. Moreover, if you're spending all of your time on caring or working full time, etc., when are you meant to prepare for this? Also, if there are language barriers or disabilities among the parent, then they can be other factors that are relevant to the securing of exceptional case funding. So at least 3 providers have started getting exceptional case funding, and it's actually all of the cases I've worked on, it's been granted, which is a blueprint, we hope, for exceptional case funding being applied for more regularly where the criteria are met. It won't be every case to SEND tribunal because they might be too straightforward, or there might be, the person might be considered able to represent themselves. But hopefully it will start to be being applied for more. Equally, Alex and I are having conversations about the potential to apply for exceptional case funding for the independent review panel hearings, where these judicial review principles are meant to be used. Clearly complex. So potentially there's scope there as well. But whilst this is out of scope and exceptional case funding is needed, we're never going to get a huge number of applications because the process of submitting an application takes quite a long time. And for a law firm to do it, it's work at risk, which they might never recover when they're already working to very fine margins. What's more, the timescale, the legal aid agency can take a very long time to determine these applications, which might render the issue academic if they determine it a day before the tribunal or even after the tribunal. You're not going to get representation in place. So there are still loads of problems, even though we've had success getting exceptional case funding granted. I want to talk about access to judicial review. And that's where what strategic litigation is, judicial review. The first tier tribunal, whilst you can take it to the upper tribunal and make some really important points and get the law change, which Polly has done in a really important case called C&C. Generally, it's judicial review that you bring a systemic challenge saying that policies are inadequate. And the means test still bites, and I don't want to go into the complexities, but if you've got a child claimant and you get through the first hurdle for the certificated stage, then it's potentially just the child's means that you look at rather than the parent's means for a systemic, for a challenge in the education sphere. But as Polly said, there aren't enough people doing this work. It's really hard to get hold of a public law solicitor, particularly in some areas outside of London. And more rural areas, there might not be any public law solicitors that you can go to. But it also requires knowing that, like what Amanda was saying, it requires knowing that there's something wrong legally for you to try and approach a lawyer or think of it in legal terms and having legal solutions. So we definitely need to think about public legal education hand in hand in any attempt to improve access to judicial review. I just briefly wanted to mention a project that I'm working on with a couple of other lawyers, which is trying to make the judicial review process more accessible. And as Polly mentioned, the first stage of a judicial review is sending a pre-action protocol letter, which are commonly known as PAPs. And we're trying to develop a model based on one that has been adopted by Dighton Pearce Glynn, a leading human rights law firm, and also adopted by the Child Poverty Action Group, which does brilliant work around welfare benefits. They have had set up PAP projects in relation to asylum support and welfare benefits issues, respectively. And they work hand in hand with other charities, campaign groups, etc., developing pro forma PAP letters, which then get adapted and upscaling the number of people that can access at least the first stage of judicial review. And they're really good for challenging straightforward unlawfulness, because quite often public authorities, when they know there is no potential for an individual who's being screwed over by them, basically, to access public law remedies, they act with impunity. And what we want to do with this PAP project is to challenge local authorities that think they can act with impunity. These aren't going to be complex cases. They're straightforward unlawfulness where families cannot access legal aid lawyers or public lawyers to help them with bringing a PAP letter. So it's still in the nascent stage. We're working it up with working with various different organisations in the sector. Watch this space, because we need to make judicial review more accessible to send families so that they can hold local authorities to account where they're just egregiously breaching the duties that are owed to children and young people under the Children and Families Act 2014. And I think that's the end of my presentation, and hopefully I haven't gone too much over. Thank you very much.
So we can see, I think I can see you talking, but we can't hear you. I don't know if anyone else can hear you.
No.
Sorry to be the bearer of bad news.
We can see you, Hafsah. Until Hafsah's sound comes back, maybe I'll cover and pick out some questions. Feel free to Yes, Hafsah sent me a message to say that there's a problem with her sound and she apologises. Not your fault at all. These things happen, Hafsah. So in terms of questions in the chat, I'm just having a look through them now. I think probably worth mentioning, we can't give specific legal advice to people about their cases as much as we might want to. This isn't the right forum for that. But Polly's very helpfully put in an answer to one of the questions in the chat in the Q&A about the Article 39 case, which Steve Broach was one of who was mentioned by Amanda, was one of the counsel in, and an absolute hero to many junior SEND lawyers. So check out that question there. If people have more questions, please put them in the Q&A box.
Ollie, do you mind if I there's one from Mick about
yes, great.
Do you want to pick that up?
Yeah,
just
great.
Because this is it's a really good point and a really important year for people who are interested in making change to the exclusion system. So Mick said, is the work on the exclusions report by Justice being taken forward to be looked at by the Department for Education? What's happening with the report? So Justice are still working on delivery of the report. I'm not entirely sure where they're up to with that. I haven't spoken to them for a few months, but they were doing a really great job in getting interested parliamentarians involved. But it touches on a number of the things that are happening this year at the Department for Education, or theoretically this year, that I would encourage people to get involved with if they can. The first is that the department is committed to rewriting the statutory exclusions guidance. The exclusions guidance is basically like the primary source of law for it's the primary reference point for everyone involved in the exclusions process, and so its rewrite is a really important event, and it can go right and it can go wrong. In 2015, they issued guidance that had to be very quickly withdrawn after threats for judicial review, again pointing to the really important and really valuable work of strategic litigation in this area, and just glossing over the fact it was just for kids law that was involved. And so this year we need to really keep a really close eye on that guidance. They will be consulting on it, and anyone who is interested in feeding into that consultation, who has lived experience, absolutely definitely get involved. The one thing that the department tells us when we're talking to them is what the ministers want to see is stories, 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 because the officials can go to them and say this doesn't work, and this doesn't work, or this could be better. And they say what the ministers tell them is we want stories, what's actually happened on the ground. And so I think that the problem is that these consultations are often aimed at organizations and charities, when actually the people with the most power to feed in and make an impact are those with lived experience, which is exactly what as it should be. Other bits of guidance coming out this year relevant to how disabled young people are treated in the exclusion system is there should be one on isolation. So again, there was a judicial review a couple of years back saying that we need more guidance on how young people are internally excluded, so separated from the mainstream school population but kept in school. There currently isn't really anything on that, and the government is committed to making some guidance on it. And another one on managed moves, the process of moving children between schools by agreement. I can't promise any of that will be this year. I think COVID has kind of kicked it all into touch for a little bit, but it will happen. And anyone who has experience or who basically just wants to be involved in shaping those consultations, I encourage you to keep an eye out and keep an eye on Send Twitter because they will definitely circulate.
Brilliant. Thanks for that, Alex. There's a question that might be for Polly or for you in particular from Beth Parr, and it's in the chat. What key resources would you recommend for a trainee solicitor qualifying into public law and hoping to specialise in education? So Polly, do you want to take that first?
I think that the first, a little bit biased, the first book I would recommend is one that I contributed to, which is the Legal Action Group Legal Handbook for Disabled Children. It's authored, the main author is Steve Broach, but it's a great book. There we go. I'm glad to see Ollie has got a copy.
On my desk at all times.
Wonderful. But for those people that aren't in a position to be able to buy the book, the Council for Disabled Children have published bought the copyright for it and have it published for free on their website. So Council for Disabled Children website has a full copy of the book with all the chapters in it. So it's a really good reference point. Also for SEND, one of the problems I think we have with Education JR is, unlike many areas of law, first of all, the first tier tribunal judgments don't get published, and the upper tier tribunal judgments are very hard to find. You have to rely quite a bit on social media and having a close network of people to keep on top of the law in this area, which is another problem with accessibility, I think. But there are a number of barristers at Matrix Chambers and Landmark Chambers who produce a noddy guide to SEN, and even I use that as a quick reference point when I need to quickly look at what's the latest case law on quantification or what Section F education trains means. So the noddy guide, and then my final one would be if a case law updates, the CDC, again, Council for Disabled Children, do case law updates for all upper tier tribunal judgments in the SEN tribunal on their website. So that's my 3.
Thanks so much. Also, huge apologies for my Wi-Fi issues today. I cut out just when I was thanking Polly for hers, but also thanks again for your talk as well, Ollie and Alex. I'm going to continue with the Q&A. We've had some good questions coming from the other chat function that I don't know if is visible to everyone, but I'll just read out one of them. It related to whether there's any resources for people interested in this area, people kind of coming up, aspiring lawyers, but also aspiring kind of campaigners and those interested in social justice and getting involved in things in general in terms of supporting children, disabled children in particular. What would each of the panelists recommend in your kind of respective roles?
I've done my top 3 already, so I'll stick with those and see what Alex and Ollie have to say.
Okay, thanks. Thanks, Polly.
Who's going next? Okay, cool. Well, it's an interesting question. I think, I mean, I don't know whether this is something that Amanda would agree with, but obviously, one of the most important things is to follow not just the legal literature, but what's actually happening in the policy realm as well. So following blogs like Special Needs Jungle, for example, and as much as promoting Twitter can be a dangerous game to play, there is the education sector of Twitter and the SEND sector of Twitter is both incredibly active and very supportive, and you keep up to date actually pretty effectively by making sure that you're linked in with the right people on there. Finally, I mean, there was another question I think I could conflate this with about the availability of work experience during COVID-19, which I think is a really, really good question. And all I would do is I'd say for anyone who's aspiring to be a lawyer in this area, do very, very much make sure that you're plugged into the Legal Education Foundation and the Justice First Fellowship. That's how I trained. I was at a commercial law firm, which was fantastic, an amazing experience, and no doubt I wouldn't be here if I wasn't for what they offered. But it wasn't until quite late in the day that I found out that there was something called the Justice First Fellowship, which is a training scheme funded by the Legal Education Foundation, where they fund organisations such as Just for Kids Law, and Public Law Project, and so many others to place trainees within the organisation, and their aim is to train the next generation of social welfare lawyers. There is no way that I would have been able to train at Just for Kids Law if I hadn't had that opportunity, and I can say that it was the best decision I ever made. It was an amazing experience, hugely eye-opening. I'm hugely privileged, and it's absolutely vital to making sure that we do have more lawyers in this field who are specialists at working with in niche areas that are difficult to fund. So definitely, if you're interested, make sure you're following Legal Education Foundation and keeping up to date with the progress of the Justice First Fellowship.
I'm most interested in hearing from Amanda, so I'm going to be really quick, and it reflects some of the other questions in the chat, which is, if you can, volunteer with IPSI. It's an opportunity to get trained up in SEND law. You get a weekend-long training course, and then you have to commit for 2 years to be a volunteer tribunal advocate. And I'm still doing that. The case I'm doing on Friday is an IPSI pro bono case, and they give you lots of support when you're you can start when you're a student, and they train you up and you get experience in the first tier tribunal, and it's a really great opportunity and a really great organisation. and that's IPSEA.
So, I mean, I can't give you any advice in terms of career routes or anything else, but what I would say, and I would echo Alex and Ollie's, Send Twitter is phenomenal and is ever growing, and it's an amazing community of families. Often parents who are IPSY trained, they're not lawyers, but they have a really good grasp of how the law, and often they're volunteers. So if you need to connect with people and understand what's going on the ground, that they are phenomenal. There's some great charities out there, the CDC, the Disabled Children's Partnership, Special Needs Jungle is everyone's favorite go-to news if you want to know exactly what's happening. Send Action, we're not actually an incorporated charity, we're basically a network of families, and we work very closely with Special Needs Jungle and all the sort of satellite organisations. So we're a network rather than a sort of formal charity like some of the bigger ones. But if you need to speak to us, you're looking for, I think you were talking about lived experience for some of these strategic litigation. I mean, you're right, Twitter can be a sewer, but it's also, people are at your fingertips really, and people will help you find. It's incredibly supportive, incredibly informed, and some very engaged parents across the piece, and that's been the big boost for everything around disabled children in the last 5-10 years. So those would be my recommendations. We're really, as a you know, everything's been a bit weird in lockdown, but we've been discussing and talking about campaigning still, and there are still actions going on, and even in Hackney we're still waiting for our appeal. So things light up when things happen, so just keep an eye on Send Twitter, definitely. Thank you.
Thanks so much. Really great suggestions from everyone. Another question, it's regarding resources again, but it's more related to what resources would you recommend for parents of children who are becoming adults, but they have many issues with transition to adulthood, a child's future, and ECHP? That was a question from Ikra. I think that everyone will have something you need to say on that particular question in relation to parents and support for parents. If I can come to Amanda first, and then anyone else that would like to chip in, please.
Yeah, I mean, I don't have any advice. We know it's a cliff edge. It's a cliff edge for families, and we've seen a lot of fall off. It's often an opportunity where local authorities will try and seize the chance to push young people. So typically, if you've got a school with a sixth form, often disabled children don't make the minimum academic criteria for being able to go to that sixth form. So they're pushed to colleges and put on vocational courses. And often what happens is they're very quickly because they're so desperate to get these children off their education budgets. There's a lot of ping pong that goes on with social care budgets, even within the same local authority. They're trying to get them off their books and their budgets, and they're really losing out, because actually when the Children and Families Act came out, there was a big sort of hope that there would be sort of sensitive, clever planning around education, health and care plans for disabled young people that could create like a sort of a smorgasbord of support, you know, social care, speech and language, vocational training, a bit of college, and that the plans would enable that. But what actually happens in reality is they're busy trying to get them out of formal education and onto a vocational supported employment track, and then take the support away. So I don't have an answer, but I know what the problem is, and that's one of them. So yeah, vigilance always.
Yeah, Alex or Polly or Ollie, if there's anything in addition in regards to parents and support in particular.
I think I would say, starting off by well in advance of transition, parents, and I appreciate some people don't realise that this has gone wrong until they get there, but make sure you know what your legal rights are at a really early stage, so you know what you need to be asking for. and you know what should be happening in advance. And so the starting point for transition to adulthood should be at year 9, and that's very clear from the SEN Code of Practice. And so making sure that you get yourself familiar with legal rights for transition. There's often, like all of the organisations that we have here today, there's lots of information available on that. But yeah, get yourself up on your legal rights. Code of Practice has a really good section on preparing for adulthood. So read that section of the Code of Practice. That is statutory guidance, which means local authorities have to comply with it absent good reason. So if there's a bit of the statutory guidance which said something must happen, you can quote that at the local authority. So you're kind of empowering yourself to be able to making those legal arguments. And then be, I guess, ready to identify when things have gone wrong and taking prompt action. We see cases where parents have battled for years and years and years, and you just see.
I think we just slightly lost the last minute of what you said, Ollie.
Oh, I'm so sorry.
I heard it, so I think it might be your internet, Hafsah.
So I would say that, yeah, and then just be ready to identify when legal breaches happen so you can take action promptly. That doesn't mean necessarily jumping straight into a judicial review, but just being aware of when legal rights are being breached. So those would be the top things from me. Thanks,
Polly. I thought it was your Wi-Fi, but it was mine. But everyone else heard what you said. That was great. So I'm going to take 1 or 2 questions before we close the time. It's gone so quickly. I think I will divert to. I'm going to just summarize one of them. I think Ollie, you might be able to respond to this, but an aspiring barrister mentioned anonymously that she has experienced school exclusion in the past as well, but I think that those experiences will enhance your application, your perspective in the coming into the profession. So I think there's nothing to worry about in that regard. But if there's anything that you would add, Ollie and Alex, in relation to that and easing any potential anxieties that people have going into a career in law, their school experiences should not hold them back in any way. I think they would actually benefit them. But is there anything that you would add in addition to that for one of the attendees?
Only to echo that, I think in this area of law in particular, having empathy or lived experience that particularly can come from lived experience is really valuable. So I had lots of speech and language therapy when I was at school, and that probably drove my interest in special educational needs, and I hopefully means that I can understand the issues from both a personal perspective as well as a professional one, and while keeping a professional distance, and particularly that's the case for barristers who are generally one more step removed from families. So I think having that understanding of the stress that's on a family and the stress that's on everyone involved can only be a good thing as long as you manage it and remain professional at all times.
I don't think I've got much more that I can add to what's already been said. That was, I think, both very accurate. The only thing I might say is just to bear in mind, particularly if you're looking to work with individuals and young people who have been impacted by issues like this, then one of the really big stumbling blocks that we often face, and this is true as well for lawyers practicing in criminal law, is that they don't know how to talk to people who have who are going through something that they've just can't possibly imagine or haven't experienced. I know that's something that I'm acutely aware of all the time. Is that I've seen this in my personal life, but because I haven't lived a lot of these issues, I have to work really hard and listen very carefully to the people who have, so I know what they actually want out of the process and what they want out of my my support. And so I think that a lot of organisations, at least the ones that have got their priorities in order, will welcome those kind of experiences. And the only thing I might add very, very quickly is, and I don't know whether this is helpful to people, but there's so much misinformation out there about what an educational record does and what it is. I've had even seen published information about suggesting that if you do a police check for information applying for a job, that that something that happened at school that was never reported to police can appear. So, for example, it might reveal the fact that you're excluded for some kind of incident at school. It's false. It's not true, and it doesn't follow you that far. And it's important to get perspective on what an education record does and the fact that it doesn't define you, and it's not something you've got to tell people about, and you leave it behind once you leave school. So I suppose just to be operating with the right information as well is really helpful.
Thank you so much for all of those responses. I was going to take one more question, but I think I'm going to close the event there. If any other questions come in, feel free to email me or message me, and I can circulate some responses over Twitter. I'm on Hafsah H24. But thank you all so much. Apologies again for my disappearance halfway through, but it's been so lovely to hear all of your reflections and perspectives and kind of further into this discussion. And I'm really excited to kind of develop this work further. And with YLAL, we have our events every 2 weeks, and we're always kind of making sure that we are, on top of issues and ensuring that where conversations need to be had, we're bringing together speakers such as yourselves to have those necessary conversations. So thank you so much again. I think that, did you want to say something, Ollie? It seemed like you had. Okay. I don't think that there's anything else I'd add. Please do follow the live tweet on Twitter, and we'll be sharing those resources. And if anyone would like a copy of Alex's slides, just get in touch and we can circulate those. Thank you so much again. And to all the panelists, apologies we couldn't get to all of the questions, but I really appreciate everyone's input tonight, and hope you all enjoy the rest of your evenings. Thank you so much and take care.
Thank you so